next speaker is Jean-Louis Fabiani, and he brings with himself a splendor of two excellent institutions. He's a professor of sociology, if I think it correctly, at the Central European University in Budapest, an institution very close to my own personal heart. And he's also a Directeur d'études of École des Hautes Études en Sciences Sociales.
Now only.
Only. Oh. And, well, he expressly mentioned, asked me to mention only his last book, and I'm following his wish in doing so. And I was only going to say that an interest in arts is very pronounced in his publications, which is very welcome in this center. But his last book is on sociology. The title is La sociologie comme elle s'écrit, de Bourdieu à la Tour. And hence my idea that maybe Bourdieu would come up in this talk, the title of which is Contract, Context, Social Action. The floor is yours.
Thank you very much, Marta. Thank you, Werner, for inviting me. Thank you to the wonderful team who here makes our conferences really delicious. And we come back every time with enthusiasm. You invited me, but I'm not. I'm only a part-time Durkheimian, and I'm not a legal scholar. But I try to be serious. Tout n'est pas contractuel dans le contrat. And I have your answer. Encore? Assez. Get hooked. Okay? And the legal scholars will tell me, so what? What's new? We knew it. We don't need sociology to teach us, to document the obvious. But I would like to go further. In the contract, not everything is contractual. This is undoubtedly one of the most famous statements made by Durkheim. It plays a central role in the argument of the division of labor in society, as it is directed against pure contractual visions of the social nexus, and repeated in later works devoted to the legal and economic dimensions of social life, particularly in the very often quoted today Leçons de Sociologie, Professional Ethics and Civic Morals, the Istanbul book, a posthumous book by Durkheim, his lectures from Bordeaux to the Sorbonne, published by a Turkish student. Durkheim writes in La Division du Travail Social, I quote in French, and I will explain. Mais ce n'est pas seulement en dehors des relations contractuelles, c'est sur le jeu de ces relations elles-mêmes que se fait sentir l'action du contrat. Car tout n'est pas contractuel dans le contrat. Les seuls engagements qui méritent ce nom sont ceux qui ont été voulus par les individus et qui n'ont d'autre origine que cette libre volonté. Inversement, toute obligation qui n'a pas été mutuellement consentie n'a rien de contractuel. Or, partout où le contrat existe, il est soumis à une réglementation qui est l'œuvre de la société et non celle des particuliers, et qui devient toujours plus volumineuse et plus compliquée. End of quote. The contract is both the expression of two free wills, that should not be questioned, and the effect of a complex form of social action expressed through an ever-growing set of regulations. Réglementation is sort of difficult to translate into English because it includes the règlement, and it's complicated. In order to understand the essence of the contract, we must, according to Durkheim, combine two sets of historical processes in the long run. The first, of course, is the development of the free individual in the long run, and the second is the social work of society that produces and enforces rules, and always more and more rules. This is something interesting, this accumulation of rules in modern times. A contract does not exist in itself. It can be understood and applied only if we consider its social context and the social forces that exert the action. I would like to say that Durkheim's reflection on the contract is one of the founding acts of sociology. I am a historian of disciplines, and of course, as you know, there was no sociology even when he died. Okay, and in 1913, for the first time, the word sociology was mentioned in his course on pragmatism. But of course, as Werner reminded us, Durkheim was a professor of science of education, not only in Bordeaux, but also at the Sorbonne, when he took the job really reluctantly, because he would have preferred to have a chair in sociology, but it was impossible. So, it's a founding act for the new discipline, or the new science, because it attempts to think together the process of individualization and the emergence of a legal moral society. The analysis of the contract is a decisive test for the new science. If sociology passes it successfully, it will be able to find its own space, besides legal studies, philosophy, religion, and economics, while providing an encompassing frame for all social phenomena. In his analysis, he could not join, so I will make him present this evening. In his analysis of Durkheim's theory of contract, our friend Jeffrey Alexander shows, I think he thinks that he shows, that the sociologist is trapped in a contradiction. I quote him and comment on him in the meantime. I quote, "It is in the nature of special task," he writes, "to escape the action of collective conscience." So, of course, the way to modernity is an escape from collective conscience. The contract itself, I comment, according to this logic, becomes a prototypical form of cooperation and aggregation. So, a way of constructing the social that is aggregative. I quote again Jeff, "Since society is made up of a system of differentiated parts that mutually complement each other, it is only natural to assume that the involvement of one party results either from the involvement assumed by the other or of some service already rendered by the latter." End of quote. But, according to Jeffrey Alexander, as Durkheim develops his argument, he feels that he is trapped in this contradiction and, of course, is forced or obliged to emphasize the non-contractual, supra-individual controls that are necessary if the freedom inherent to labor division is to be balanced by stability and collective control. And Jeff concludes, Durkheim vacillates, all the time between describing these collective elements as normative and non-rational, or as state-directed and instrumentally coercive, and, of course, these individual way of contracting. My question is Durkheim vacillating, or is he trying to define the social nature of the contract in other terms than the dominating vision of a society made only out of the aggregation of individuals or individual contracts, inter-individual contracts? Can we, on the contrary, defend the idea of a form of coherence in Durkheim's theory of the contract? To sustain his analysis, Alexander does a bit of sociology of reception, a little bit quick to my view. Paradoxically, Durkheim, who identified social with moral from the start, was seen, when he published The Division of Labor, as a materialist, a chosist, a thingist, an inheritor of Marx, or as an advocate of utilitarianism. Two quotes are brought by Jeffrey Alexander to illustrate that unfortunate reception that he calls the predicament of Durkheim. Charles Handler first, and you know it. Monsieur Durkheim generalizes the economic thingism of Marx while making from it a thingism that is specifically sociological. In doing so, he generalizes the Marxist error, end of quote. And Paul Barth, in the Philosophie der Geschichte als Sociologie, Durkheim is, like Spencer, an almost superstitious worshipper of the contract, and he views morality as a hindrance to economic progress and as unfavorable to the autonomy of the individual, end of quote. So either Spencer or Marx, as Durkheimian scholars. And we know that Durkheim was neither a Marxian nor a Spencerian, and that is clear even from his early writings. Durkheim answered those criticisms with sharp arguments, but of course, I will not address today, because I have a divergence with Jeffrey Alexander, I will not address today the issue of Durkheim's drastic theoretical revision advocated by Alexander after others, Parsons, Davy, Breyer, and a few others. I am not convinced by the spiritual or cultural turn in Durkheim's work, but of course Jeffrey Alexander needed a new founding father for the new cultural sociology. I would rather like to stick to Durkheim's early argument on contract, as it was reworked without really significant alterations in the second part of his career, as the Leçons de Sociologie clearly show. I agree with my colleague and former student, Claude Didry, who started to write on Durkheim after my cours d'agrégation on Durkheim 35 years ago. Claude Didry writes that the contract establishes the field of sociology in modern societies at the heart of the contractual order, against the theories of spontaneous generation of a social order based on strictly individualistic behavior, either rational or mimetic. End of quote. Didry even compares Durkheim with Pasteur, okay, the microbes. According to him, the law makes the social evident as it is grasped through institutions that allow to organize and identify social relations. I agree with him. Of course, the division of labor is not totally exempt from evolutionist overtones, you know that, and some remnants of the Spencerian utilitarian conception of industrial societies, in spite of his efforts to distinguish himself from his predecessor. Durkheim is writing his doctoral dissertation. La division, c'est ça. And it shows, in some ways. We saw that with Jean-Louis this morning. Today, it should be rewritten for publication. However, Durkheim never disowned his first work, and the preface to the second edition was more a clarification and a reaction to unfair criticisms than a partial rewriting, as the one in the rules. Before going further, I would like to reassert the reasons why, within the contract, all is not contractual. This is due to the presence of social action as a frame, I would say, in a quasi-Goffmanian sense. At the center of contractual relationships, social action exerts powerful effects. This is la force du social that Claude Gauthier, in a wonderful book on Bourdieu, attributed to Bourdieu's work. Okay? And these effects, of course, can be seen particularly in the Article 1135 of the Code Civil, we mentioned it this morning, that says that the execution of the contract obliges the parties to all the consequences that equity, custom, or law give to the obligation following its nature. The organic solidarity brought about by the division of labor doesn't mean that all the interests are solidary. And there is room, I would say, we can discuss it in the future, for a conflict theory in Durkheim's work. Okay? Different individual interests are distinct and rival and remain so in the exchange. Each contracting part, while needing the other part, seeks to obtain at a minimum cost the maximal rights against the minimal obligations. There is no such thing as a spontaneous equilibrium of exchange. The equilibrium is produced by the contract law that allows to avoid an indefinite negotiation on contract rules. As Didry shows, contract law manifests the power of social action within the most individual of legal acts, signing a contract between two individual parties. Durkheim notes that the contract is less about creating novel rules than about furnishing particular cases to rules previously established. Social action is mainly manifested through law, although Durkheim gives some room to customs and mores in some, I think, confusing way. The efficiency of the contract law, seen as a constraint external to the mere contractual interaction that would not make sense as an atomistic encounter, as a person-to-person arrangement, illustrates, in my view, the presence of a society sui generis, we heard this term this morning, that stands upon individuals. It makes the tangible evidence of a society that would not be the aggregation of individual wills, as it appears in liberal theories, but in the meantime, it expresses the power of individual wills. It is clear that Durkheim does not envisage all the consequences of such a complex construction, the two lines I mentioned at the beginning, as he does not see the contradictions inherent to, he sees them, but I mean in a sort of haze, inherent to organic solidarity. It is not true that Durkheim does not understand the importance of conflict within the division of labor, as the analysis of individual contracts shows. The attempt to get the most of a contract is not the symptom of social pathology, a malfunction of the division of labor, but on the contrary, is inherent to it. Division of labor does not dissolve social constraint, as it could be seen in the manifestation of a liberal social life, a fully liberal social life, but I would say requalifies it as a regulatory process. Law is the symbol, and we are back to symbolism of society, its most tangible manifestation in a time of individualism. Its role is analogous to religion in earlier societies. It is thus more than a regulatory element, it helps society to represent itself as a collective order. This might be called the paradox of individualism. The end of a status society and the rise of the individual do not mean that the social nexus is weaker. On the contrary, the disembeddedness of the contract brings a set of new and constraining obligations. We might say that the reign of the contract is in some ways more constraining than the early forms of socialization. It is highly significant that Durkheim, in his Leçons de Sociology, largely devoted to contemporary society, goes back very far in history, and of course evokes Robertson Smith and his analysis of the blood covenant. In that type of covenant that still belongs to status societies, two individuals or two distinct groups who are not tied by natural links or biological links agree to associate with the purpose of a common endeavor. In order to create a reciprocal obligation, they concretize a material consubstantiality that is now considered as the source of all obligations. As the young Durkheimian scholar Mélanie Plouvier, a young woman who defended the dissertation in 2010 on Durkheim, and she brilliantly showed that the blood covenant can be analyzed as a seed of contractualization in status societies. Status prescribes obligations that are not contractual, as you know. Those obligations cannot be negotiated and are grounded on a natural order, mainly kinship relations. By mimicking kinship relations based on identical blood or made identical by alliance, individuals or groups create a new state that is not included in their status, as it does not allow any type of covenants. The goal, Plouvier remarks, is to create obligations beyond the constraints involved in a personal status. But the action is limited by the very fact of the mimicking. The merging contract is expressed within the frame of the status. It is an artificial reiteration of the status. But there is something at work, at least in the blood covenant, that tends to go beyond the mere status law. Is Durkheim following without any, this is a question, is Durkheim following without any distance Henry Sumner Main's clearly evolutionist scheme as it was presented in Ancient Law? Jeffrey Alexander seems to think so. In the division as well as in the Leçons, Durkheim analyzes change within a time frame that is constructed by the slow emergence of a human individual will. But one can see some elements that contest a simple evolutionary unilinear track. There is never a simple line going from status to contract. You know, this sort of cliché in the history of law. Taking Durkheim's argument out of its evolutionary envelope is, of course, a theoretical decision that you can contest, as it would be impossible to find a constructed critique of Sumner Main in Durkheim's work. As usual, Durkheim relies mainly on published work and largely depends on his sources. However, and I follow again Mélanie Plouvier when she analyzes Durkheim's position as plurilinear. Okay? After a close reading of the leçon, she is able to write that the history, I quote, "the history of contractual law proposed by Durkheim is less evolutionist and theological than it is usually presented. Clearly, there is no major difference between Sondermain, Weber, and Durkheim. I mean, in a broad view. If one considers the main theme, modernity is characterized by the central role played by private contracts. Okay, but what is then Durkheim's originality? This is my own claim. I think this is this capacity to go out of this unilinear scheme to account for the passage from status to contract. Durkheim's physique of mores and law is based on the study of moral and legal facts. There is no strong distinction between legal and moral. This is always a problem I have with Durkheim. Durkheim writes, moral and legal facts, we'll say briefly, moral facts tout court. This tout court, for me, is a problem, of course, and it will remain a problem until the conclusion. How long do we have?
Oh, at least a quarter of an hour, I think.
Oh, good. Okay. You remember this very ambitious beginning, of course. Durkheim was in Bordeaux at the Sorbonne with a very, attentive public, and he has a huge program, even for a year, for a sociologist. He's very, a sort of hubris of the young sociologist. 2 questions: how were the rules constituted in history? What are their causes and ends? And second question: how do they function in society? How are they applied by individuals? Okay, so of course he does not answer those questions properly, I think, but he's very interesting nevertheless. Starting with professional morality, Durkheim links the strength of a rule to the frequency and intensity of social interaction. Those are not exactly Durkheim's words, interaction of course, but I try to emphasize one of the key elements of the reasoning. The cohesiveness of a group is based on the number and the intime, the intimate character of contacts within it. Plus ces contacts sont fréquents et intimes, plus il y a d'idées et de sentiments échangés, ideas and feelings, plus l'opinion commune s'étend à un plus grand nombre de choses, précisément parce qu'il y a un plus grand nombre de choses mises en commun. End of quote. It's page 47 of the French edition of the leçon. There is a clear link here between a form of physical density, you know, the morphological argument, and the development of morality. Here we can find the morphological determination of morality. The notion of contact, we would say interaction, is also used by Durkheim when he wishes that industrial life be organized. I quote again. Qu'on organise la vie industrielle, c'est-à-dire qu'on lui donne l'organe dont elle a besoin, et cet organisme de lui-même, spontaneously, de lui-même, en entrant en contact avec les autres organes sociaux, deviendra une source de transformation que l'imagination ne peut guère anticiper. End of quote. The conclusion of the 3rd chapter on professional morality, from which this quote is taken, is missing. You know, it was typed. The scholar had a manuscript and written a typed version, and things were obscure. I think obscurities remain in the book, but I don't want to be long on that. The interpretation of the last readable lines is thus sort of difficult. This l'imagination ne peut guère anticiper. It has to be related with what we said about the conclusion of Werner's presentation. So, what is striking, in my view, is the conjunction of a voluntary gesture, I think from the state, as it is the spatial organ in charge of elaborating some representations that are valid for the collectivity, and the spontaneous dynamics of unpredictable changes. As Durkheim often says, we are not spontaneously inclined to contrain ourselves. Morality, to prolong Daniel, morality is a form of habitus. But contrary to Bourdieu's habitus, it never commutes automatically from passive to active. What is the definition of habitus? It must be constantly made present by the action of the rules. It would be weakened otherwise. This remark, page 51 of the French edition, shows Durkheim's realism in this respect. The development of a society based on self-interest has undoubtedly weakened the moral link, as there is nothing above the individual that can contain her egoism. The chapters devoted to contract follow the development of property rights, as we said this morning. Durkheim, of course, recalls their constitution as, and here again I use my own lexicon, a transfer of the sacred toward the law. I quote again, la religiosité diffuse dans les choses, qui les soustrayait à toute appropriation profane, a été reportée au moyen de rites déterminés, soit au seuil de la maison, soit à la périphérie du champ, et y a constitué ainsi comme une ceinture de sainteté, comme un remblai sacré qui a protégé le domaine contre tout empiètement étranger. Page 198. End of quote. Two central notions here. Holiness belt, sacred bank, le remblai sacré. There is a transfer of religiosity from things to persons. The notion of personal property is the consequence of that transfer. Durkheim grasps immediately the paradox lodged in the transfer. We account for a major innovation in human history by referring to old religious beliefs. In order to solve the paradox, this is my own reading, of course, Durkheim uses two different argumentative lines. The first is general. If religion is never true à la lettre, he says, it nevertheless expresses social realities. Religion, as we have seen, is a metaphoric and symbolic translation of actual social facts. Religion is society. The second argument is specifically related to the case. The sacred character of property expresses the sacred character of the individual. Property is sacred to the extent to which the individual is sacred. This sacredness is transferred in turn to the objects possessed by the individual as the individual's extension. This is Durkheim's vocabulary. In order to pursue her goals as an individual, she must have a domain conceived as a material sphere of activity, an extension that confirms and guarantees her existence and rights as a person. Property rights are the material conditions of individual sovereignty. In using the notion of transfer of sacredness, I'm not mistaken, I think, this notion, of course, you remember, was developed by Mona Ozouf in La Fête Révolutionnaire, as I've used it in my previous work on Durkheim, that was more that dealt more with the art in Durkheim's work. But with this notion, I try to grasp the complex mix of secularization and resacralization that affects the modern world through legal procedures. Here, Durkheim does not seem to see the discrepancy between his two statements. In the first one, sacredness goes from God to things, and then from things to individual. In the second statement about property, sacredness goes from God to individual, then from individual to things. This is due to the fact that Durkheim can't inscribe the chain of transfers in an actual historical process. Durkheim's analysis of contract is a direct outcome of property rights. How can property be transferred? Either by inheritance or by contract. As you know, Durkheim considered that inheritance was a remain of archaic practices devoid of any actual foundation in our societies. This was a sort of vanguard position, and Durkheim was not so frequently on avant-garde positions. Thus, he devoted his analysis to contracts. Significantly, he starts with the dismissal of the alleged simplicity of contract. Contract is never the elementary form of social life, or elemental as recently translated. It is not primitive, but is the final outcome of a long and sinuous process. The social contract is the product of that error, okay? Taking the end of process for the beginning. And a contract is never simple as it involves a mix of legal forms and social action, as already said. Bien loin que l'institution du contrat soit primitive, elle n'apparaît et surtout ne se développe qu'à une date très tardive. Bien loin qu'elle soit simple, elle est d'une extrême complexité et il n'est pas facile de voir comment elle s'est formée. And of course, to account for that complexity, Durkheim produces a kind of genealogy of the contractual link. And of course, I was not aware. I saw that it was a little bit pompé, as we say in French, but I did not know that he just reproduced Adhémar Espin's work about the primitive forms of contract. But okay, vilain, Durkheim. Okay, but he was not interested, I think, he was interested in his own framework. I have 4 minutes? 4, okay, that's enough. We simply know the process is not precisely described, but it's natural because it doesn't have the means to do it. Il say that cette évolution s'est faite d'ailleurs par des voies différentes. Page 295. This corroborates the idea of a plurilinear vision. Okay, so I will skip the lineaments because it's well known, I think, from the blood covenants to the actual contracts. And I conclude now with, and I will send you my piece when I remove the typos if you are interested. As a matter of fact, the secret can be located in a very specific place. At this point, we have to go back to the division of labor. Let's go back to the previous question. What is original in Durkheim's treatment of the contract? That's what we want to know. It is the notion, of course, of contractual solidarity. The proliferation of contracts in modern society brings about the weakening of rights. We can't spend a lot of time in rights because we have so many contracts, 20 a day and so on. As well as a strengthening of organic solidarity, form of paradox. Do contracts favor solidarity? Are private affairs a decisive contribution to public consensus? This sounds liberal and not Durkheimian, or like in Spencer's universal relationship. And I think that I would say that at first sight it is even a contradiction in terms. A contract between individuals remains in the private sphere. Social constraint ties the individual not with other individuals, as in a contractual society, but with society as a whole, as an entity sui generis. This twist is allowed by the aphorism "Tout n'est pas contractuel dans le contrat." A mere contract is not a social relationship, as it does not involve something more than the adjustment of individual interests. How can we understand contractual solidarity since contractors do not need this notion to contract? Is it a form of supplement, as Pierre-Michel Menger hypothesizes when he discusses the notion of surplus in his recent work in Durkheim, the Durkheimian and the Art? I will not say anything about it. As we know, the general will cannot be the result of private contracts. Both Spencer and Durkheim reject Rousseau's concept of social contract on those grounds. The division of labor, even when it is not pathological, generates social heterogeneity. But Spencer believes in a contractual cooperation that stems, rather mysteriously in my view, from the multiplication of contracts. By adding the notion of fair contract, contrat juste, Durkheim adds the social link to the private deal. The chapter 7 of the book begins with an attack of Spencer concerning the growth of contractual relations. It is a fact in industrial societies, but, Durkheim adds, it's not the only fact. Non-contractual relations have grown too, okay? And they express organic solidarity as an effect of the division of labor. So, from status to contract, but also from status to non-contract, I would say, to conclude. Okay? En même temps que les obligations domestiques deviennent plus nombreuses, elles prennent, comme on dit, un caractère public, from the domestic to the public. Non seulement en principe, elles n'ont pas une origine contractuelle, mais le rôle qui joue le contrat va toujours en diminishing. Au contraire, le contrôle social sur la manière dont elle se noue, se dénoue, se modifie, ne fait qu'augmenter. End of quote, Durkheim, 1893, The Division, French edition, page 187. Besides the contract, we have notions such as social contract and social action that produce a new moral sphere that does not overlap with the legal sphere, but that grounds its legality. The moral sphere constrains the legal sphere in terms of social action. The non-contractual is the social/moral level in Durkheimian terms. The contract is never self-sufficient, which means, in my view, that the law is never self-sufficient. There is a social norm above the legal norm that every contractor must respect to be fully legal, to produce legality. Law gets its strength from its obedience to social normativity. The non-contractual could be defined as a collective memory of past contractual experiences, understood as a slow process of adjusting rules to average cases. Durkheim does not give too many details about the historical process as usual. As Bruno Carcenti, the French philosopher who renewed Durkheimian scholarship, he writes, le droit des contrats relève de l'expérience contractuelle accumulée et formant un dépôt qui est comme un milieu normatif désormais disponible aux acteurs. Contract law depends on the contractual experience accumulated and forming a deposit, which is like a normative milieu, Umwelt or environment, now available to actors. Social solidarity is anterior to contract. It is its necessary background and maybe its horizon in a post-contractual society. Here, we are back home, la morale, selon Durkheim. Merci beaucoup.